Hi, this is Rahul. Today I am going to uh, talk about the judicial system of our country. First, I will talk about the Supreme Court. So, let's start with the Supreme Court. Before we going further, we should know about the evolution of Supreme Court. Supreme Court was established in India during British era when first regulating act was commenced in our country in 1773. By this act, Supreme Court was established in Calcutta. After this, second branch of Supreme Court was established in, we can say, Madras in 1801, and after this, third branch of Supreme Court was established in Bombay in 1823. After this, 1935 Act was commenced in our country, in which federal court was established. By this act, federal court was established. Um, after independence, in our country, federal court became the Supreme Court, which was established in New Delhi on 28th of January 1950. So I am going to talk about the appointment of the judges. So it's a very complex process before the birth of a collegium system. What happened earlier system was the appointment of right now also appointment of the judges in the Supreme Court by the president, but the earlier during of initial phase, the advice of Chief Justice of India was not clear. So due to this concern, major case was held in 1982, which was known as first judges case of our country. By this case, Supreme Court upheld that the due to blur written in our constitution that the advice of chief justice was the consultation, so it was not clear. So Supreme Court upheld that the advice of Supreme Court advice of chief justice of India would be consultative, not concurrence. But in after 10 years later, in 1993, second judge's case was held. In this case, Supreme Court reversed its order, and in this case, Supreme Court upheld that the advice of Chief Justice of India will be the concurrence, and not solely the advice of Chief Justice of India. It will binding to the President. The name suggested by the Chief Justice of India will be the judge of the Supreme Court, but it's not merely the Chief Justice of India, but two more senior judges will be advised also. In second judge's case, the birth of collegium system was also done. In third judge's case of our country, in third judge's case, Supreme Court said that there will be four senior most judge, and Chief Justice of India. There will be 5 members in the collegium system after during the appointment of the judges of the Supreme Court. In fourth judge's case, NJAC would commenced by the central government, but it will struck down by the Supreme Court because it damaged the partiality of the Supreme Court. So it's all about the appointment of the Chief Justice, appointment of the judges of the Supreme Court. So let's talk about the who will be the Chief Justice of India. Till 1973, Chief Justice of India would be senior most judge of the Supreme Court. But during the era of Indira Gandhi, the Chief Justice of India, junior judge also appointment at the Chief Justice of India, whose name was N. Roy, maybe. But in second judge's case, it was made clear that the judges of the Chief Justice of India would be the senior most judge. It was clear in this case. second judge's case. So let's talk about the impeachment of the judges of the Supreme Court. In our constitution, the word of impeachment is not mentioned. Not mentioned. This word only mentioned used for the president impeachment. So what happened? Regarding the word, the Judicial Inquiry Act was commenced in 1968. In this act, by this act, it made a clear that the process of the impeachment of the judges of the Supreme Court. In this act, there are following procedure by which impeach of the judges of the Supreme Court or High Court. Like, let's talk. So there will be first any house can start the motion like Rajya Sabha with the 50 member resignation and sorry, and the Lok Sabha will also commence this procedure. By the 100 people, 100 MPs should sign on the motion. After this motion move to the chairperson of the Rajya Sabha or the speaker of the Lok Sabha, and this motion will either a speaker or chairman be admit or not admit. It's clear. Then this will be a speaker or chairman can made a committee to judge the incapacity and misbehavior of the judge. After the clear 2/3 present and voting by the special majority, judge of the Supreme Court will be impeached. Okay, so let's talk about the power of the Supreme Court. There are a lot of powers of our Supreme Court because once a time many seniors constitutional writer who said that the Supreme Court of India is the most powerful court of in the world. So how? There are a lot of powers given to the Supreme Court, like original jurisdiction, appellate jurisdiction, advisory jurisdiction, and the writ jurisdiction. In original jurisdiction, it's exclusive power of the Supreme Court in which any cases regarding disputes, election disputes of president, vice president, and the federal federal disputes between states and the disputes between central and states. It's all power given to the exclusive power of the Supreme Court. In appellate power, under Article 232. Any constitutional matter by certificate, High Court can issue to certificate to the Supreme Court for the more clarification. And under Article 233, civil matter, by the issue of the certificate of the High Court, the matter would be bent to the Supreme Court. And under Article 234, it's talk about the criminal matters. So there are a lot of power in with the writ power. You people also know under Article 32, and so it's all about the brief discussion about the Supreme Court.